Hey everyone, this is Mark Petersen. Today we're going to talk about some common misconceptions that I hear frequently from people that come into my office about wills. Before we get into that, if you have any questions about estate planning in general, you can give us a call at Snake River Law at 208-406-9885. So misconception number one about wills is that wills do not require probate. So I hear this very frequently, that people come in and they think, hey, I have a will, so I'm not going to have to go through probate. But the exact opposite is true. Wills almost always require probate, especially when somebody owns real estate, financial accounts, or vehicles that is titled in their individual name. So if you have these types of assets and you have a will, you are going to be required to go through the probate process. Probate, typically costs between $3,000 to $10,000 on average. It has a minimum of 6 months before anything can be distributed to your heirs. So if you have a will and that's all you have, you will be required to deal with probate. So misconception number two that we hear frequently is that a living will is the same thing as a will. These are actually two separate documents that have two very distinct and different purposes. So a will is dealing with the distribution of your assets post-death, whereas a living will is a medical directive that if you're ever in a vegetative state, what kind of treatment you would want in that circumstance. And so both of these documents are important, but they are separate and distinct. So again, a will is dealing with your assets post-death and how to distribute those and take care of those, whereas a living will is dealing with medical treatment if you're ever in that persistent vegetative state, or a coma, as we often hear it called. Misconception three that we often hear is that a will can help provide for and control assets distributed to a minor. So in reality, wills do not have the ability to control the assets distributed to a minor child. So under a will, when a child turns 18, they get full access to all the money that they inherited without any restrictions of any kind. Prior to the age of 18, a guardian is potentially in control of that money and can use that money. In theory, that money that's monitored, but a lot of times there's really no oversight on the guardian and what they're doing with that money. So a will essentially allows a child's inheritance to be given to them immediately. So you have issues of immaturity, irresponsibility, and even potential financial abuse of those funds from other people. So bottom line, wills cannot control the inheritance that a child receives to make sure that they receive it in a responsible manner. So misconception four is a will protects my children if I ever get remarried. So we're talking about a merged family situation. A lot of people think that if I have a will that has my new spouse as the beneficiary primarily, that my kids will still be protected if something happens to me. In reality, the new spouse, upon your death, can actually disinherit all of your kids by changing his or her will to not include those children. And so you may have good intentions of thinking that your assets will get passed down to your kids, but that may not happen in a merged family situation where a new spouse may just decide that she or he doesn't want to include those kids. So wills do not guarantee that your inheritance will pass on to your kids when you do get remarried and have a merged family. So misconception five is that a will protect me if I ever become incapacitated during life. So wills don't provide any type of protection for incapacitated persons by themselves. If all you have is a will and you become incapacitated, you're going to be subject to adult guardianship and conservatorship proceedings with the local court system in order to have somebody appointed to make those decisions for you. So again, a will does not provide for incapacity issues and does not protect you if that ever does occur. So just to wrap that up, wills require probate. Living wills and wills are two different documents. Wills do not protect a child's inheritance. Wills don't protect a child's inheritance if you remarry. And there's no protection for you if you ever become incapacitated with a will. If you want to set up a plan that offers protections that wills don't, give us a call at 208-406-9885, and we'd love to work with you and your family.